EU när det gäller upphandlingsdirektiven. Och den som ska berätta för oss är Claudio Romanini från EU-kommissionen. Och jag tycker vi hälsar honom välkommen med en varm applåd. Föredraget kommer att ske på engelska. Claudio själv tar gärna emot frågor på 3 språk, svenska, danska och engelska. Men svaren kommer att avges på en blandning utav dem, om jag har förstått saken rätt. Eller du väljer det som passar bäst för ögonblicket. Ni är som vanligt hjärtligt välkomna med era frågor och synpunkter i anslutning till det här föredraget. Scenen är din, varsågod.
Thank you very much. And for those who were sitting and wondering about the Danish, well, the explanation is quite simple. I'm half Italian, hence my name, and half Danish. So that's the simple explanation for it. And of course, I'm quite happy to be here to give some perhaps interesting insights at what happens behind the scenes, because that is an aspect that we don't get to treat very often. And indeed, I think it's also fortunate because I can tie in with some of the remarks made earlier today, and that is, of course, always a good thing. But just to start quickly about the what it is really we're looking at. Well, we're looking at a series of proposals which have to be seen in the context of the government procurement agreement in the World Trade Organization. And if you ask the colleagues from the European Parliament, that is something they were so tired of hearing. Because very often they had quite good ideas, for instance, to double the thresholds or stuff like that. And our immediate reaction was to say, well, okay, it might have been a good idea, but we do have international obligations, so we can't do it because of the GPA. So that is something we need to have in the back of our minds. But other than that, what we are looking at are most of all 2 proposals to replace the current directives, and they are now adopted as a new classic directive for the public sector, 2014-24, and a new utilities directive, 2014-25, and its accompanying legislation also, a brand new directive for concessions, both in utilities and in the public sector. And I'll reassure you right away, I'm not going to look at concessions. I'm not going to look at utilities, or at least not very much. And I'll just very briefly mention that there are no changes whatsoever to the directives on defense procurement or to the directives on remedies. For remedies, that is a little bit a truth with modifications, because there are no changes in the sense that the procedures for remedies, the grounds for remedies, those have not been changed. But what has, of course, changed is that remedies are now also available in respect of the concessions directive. But other than that, the 2 remedies directives have not changed. And just very, very briefly, I should mention that there are 2 other initiatives or adopted directives on the international trade instruments and the directive on electronic invoicing. And those as well I just mention, but I'm not going to look at furthermore. But to give you an insight of what happened behind the scenes, well, what we need to look at is, first of all, is what were actually the objectives with these provisions. And I'll take some time to go through them because I think that it illustrates a number of points. The first objective was what was already mentioned several times this morning, the objective of simpler procedures and at the same time added flexibility for contracting authorities. An objective very much of allowing and even strengthening the possibility of what we call strategic use. By that, what we mean is simply using public procurement as a tool at the service of other policies. Very much what was mentioned by the minister of this morning, that really public procurement can be a very powerful tool to further social policy, environmental policy, in innovation and so forth. But of course, we need to be careful of exactly how that use is done, that we don't, if you want, focus so much on, say, social policy that we forget that we are still talking about procurement. So we have to have a framework of how we can use it strategically. Because that was also mentioned just before the slight break. We shouldn't forget that public procurement is not about what to buy. It's about how to buy. And that point was made earlier very, very rightly. So we don't oblige contracting authorities to buy green or to buy socially responsible or to buy innovative things. What we do is simply to give them the tools that they can use and give some frameworks as to how they can do it if they themselves decide to buy green or to buy innovative stuff. Very much also, one of the very big objectives was also that of trying to improve the cross-border access, not least, of course, for small and medium-sized enterprises. And the objective I've talked of, which I've mentioned here as being sound procedures. What we mean by that is that in a certain number of member states, there is a big problem of corruption, conflict of interest, and so forth. And what we need to do is to also to strengthen the procedure so that they can offer an additional guarantee against these factors which can really undermine all public procurement. They can undermine the confidence of economic operators and of course lead to very bad economic results. And not least, of course, also what was equally mentioned this morning, there was an underlying objective of strengthening the professionalization of public procurement. But if you reflect also very briefly on these different objectives, well, you'll see that already here there is a certain conflict between them. Because if we look at simplification, of course, if by simplification you mean having fewer rules, well, then at the same time giving more explicit provisions on how to use public procurement strategically, well, that is the two things are not going to work together. You'll have to have a certain number of additional rules. So simply judging whether or not the directives have been simplified by the number of articles or the number of recitals, well, that will give you, in fact, a false image of what happens. Because also one of the objectives was to simplify life for contracting authorities, for instance, by clarifying a whole range of issues which, under the current directives, are not settled, where at times under the current directives you won't get the answer to what the correct application is unless you combine the provisions of the directives with 3, 4, 5, 6, 7 different judgments, and of course combining these, reading these, is not always easy. So in fact, even though it might mean having more provisions, it is a simplification in our view when we consolidate the jurisprudence and put it explicitly in the directive. How do you deal with, for instance, something like fair trade criteria? To what extent can you do it? We had, of course, the Max Havelaar judgment that was mentioned earlier, but again, that is open to a whole range of different interpretations. So it is, in fact, a simplification to set it out explicitly in the directive what you can do and what you can't do. So already in the objectives, there are indeed a certain number of contradictions or certainly certain tensions which have the effect that, in fact, the final outcome has to be a compromise between these different objectives. And even more so when you think of how these directives are actually adopted, because they are adopted in a negotiation between 27, now 28 member states, the Commission, and Parliament, all of whom have their own views on exactly where the balance between these different objectives have to lie. So as with all objectives, the outcome is certainly not perfect. It is not purely simplification. It is not purely strategic use. It is a compromise with different balances from one provision to the next. But overall, and I'll come back to that, we think that the outcome is, in fact, quite a progress compared to the current directives. That it does give more instruments, more flexibility, more certainty for contracting authorities and economic operators. And in our view, there is also almost a proof in it, in that this time round we have a number of member states who are actually working flat out to implement the directives well before the deadline. Normally, what happens is that we have to check, we have to keep harassing almost member states to get the implementations in place by the latest date. And at times, we even have to do infringement procedures in order to obtain the implementation. This time round, we have, as I said, a number of member states who find the new possibilities so interesting that they are going to implement with about a year's anticipation. So that has to mean something, we think. Now, what were the main issues during the adoption process? So both internally in the Commission, before the proposal was made, and of course even more so in the negotiations between Commission, Council and Parliament. Well, one very big issue was what to do, which access should we give to procedures which involve negotiations. And indeed, at a fairly early stage, there were some pressure to have the same situation for public authorities as we have in the utilities. That is, a completely free access to negotiated procedures with a call for competition. However, that encountered quite some resistance, both internally in the Commission from other DGs, and of course also from a number of member states who were simply afraid that giving complete unlimited freedom to contracting authorities to negotiate might also mean opening the scopes for more arbitrary decisions, for corruption, for conflict of interest, what have you. But nevertheless, even though we are not arrived at a completely free access to negotiation. Well, what we do have What we do have is that indeed access is broader than it is under the current directives, and indeed we have the same access to both the competitive procedure with negotiation, the current negotiated procedure with publication, as for the competitive dialogue. Here I need to draw your attention to a translation problem in a number of language versions, because one of the cases where you can use both a competitive procedure with negotiation and a competitive dialogue is where the contract involves design. Now, when you read it in, say, Danish or Swedish, and you see the term design, what that evokes is of course, for instance, Scandinavian design furniture or super elliptic tables and that kind of stuff. But the problem, or the real meaning of it, is that this access to negotiated procedures exists not only where you want to have design in that sense, but also where you look at the definition of works contracts. Because works contracts are defined as being either the execution of the work or design and execution of the work. So in other words, whenever you have a works contract where you want the economic operator to carry out the planning, the design, in fact, of the works, in all of those cases, you do have access to competitive procedures with negotiation or a competitive dialogue. So that's something to have in mind also when implementing the directive, that the term design is used in the original English text with reference both to industrial design and to the design part in the definition of public works contract. Of course, this was, as I said, this access, broader access to negotiated procedures was something quite debated in member states between, on the one hand, a series of member states wanting much larger, if not completely free access, and others who were nervous about it. And the outcome was, on the one hand, the broader access, but on the other hand also a series of procedural guarantees to ensure that, okay, there is perhaps more flexibility, but at the same time, we have mechanisms to ensure transparency, to ensure that contracting authorities can't use these possibilities of negotiation to take completely arbitrary decisions. And of course, what we shouldn't forget either is that there is a completely new procedure, the so-called innovation partnership, precisely because one of the objectives, and this was mentioned also earlier, is to assist in the 2020 objectives of innovation, of smart public procurement, and so on. And one of the ways of doing it is by giving a special procedure which is designed really to cope with innovative projects. One of the other main topics in the discussions, and one of the most controversial ones, concerned strategic use, and in particular the award criteria. I'll come back to that in a little while, but this was certainly one of the most central issues in all of the negotiations, together with, not least, the whole issue of social aspects in public procurement. Not least through a horizontal clause requiring observance of applicable obligations in the field of environmental, social, and labor law. You'll remember that this morning the minister talked of one of the objectives here in Sweden being to use public procurement to, in fact, combat social dumping. And this is exactly what this issue is about. And as you can imagine, if you've followed, for instance, some of the recent judgments in the Court of Justice, this issue was quite hotly debated because on the one hand you have countries such as Denmark, such as Sweden, such as the UK, also in Germany, where there is a tradition of fairly high levels of social protection, fairly high levels of wages, which of course legitimately you want to protect. On the other hand, you have other member states where on the contrary, one of their major competitive assets is precisely that their level of wages is much lower. So you need to find a balance to, on the one hand, allow member states to protect a just level of social protection. On the other hand, that you don't do that by completely excluding, in fact, economic operators from other member states. So these discussions were among the most delicate in all of the negotiations. And the outcome, if I should summarize this very, very briefly, is that we have a strengthened focus in the directive, strengthened possibility to, in fact, apply those provisions in the social field or the environmental field which are, in fact, applicable obligations under national law which is compatible with EU law. So in other words, if, for instance, to take the social field, if we have participation of companies from other member states, well then of course you can enforce, for instance, application of Swedish collective agreements to the extent that that is compatible with the directive on posting of workers. So the compromise is that yes, there is a strengthening of the effort to ensure up to and including the level of protection that is settled in EU law, but not to go further than that. And of course, this strengthened focus on social provisions is in fact present, I'd say, all over the directive, more or less, because this horizontal clause is referred to in a whole range of other provisions. In fact, it is among the exclusion grounds. So if somebody has not respected, for instance, the minimum wages applicable, well, then that economic operator can be excluded. You have the same, it has a repercussion also on how we deal with abnormally low tenders, and as something completely new and also very controversial, it also has implications on subcontracting. Again, as this was among the most discussed, the most controversial areas, in fact the outcome is in itself quite a compromise. But what it does is that while it doesn't oblige contracting authorities or member states to, for instance, apply exclusion grounds to subcontractors, it does give those member states who want to focus on these aspects of public procurement, it does give them the tools to do so, a framework to do so, without having to be nervous, is this compatible or not compatible with EU law? So even if that in itself, of course, having a series of options that member states can choose among, that is a complication, but even so, at the same time, it gives quite a lot of flexibility to contracting authorities and member states, and it also allows the individual member states to make their own decisions as to what strategic use they want to use public procurement for. Now, I said that one of the biggest and most controversial issues also were that of contract award criteria. And here we also have an illustration of the difficulties of making extremely clear and transparent legislation, because this is very much a political compromise. Because when you look at the text of the directive, well, you see that from now on there is only one award criteria, the so-called most economically advantageous tender, the MEAT. So that seems fine, okay, you have just one criteria. But when you then go on to look at the substance, well, you see that this having just one award criteria is actually the expression of what I call a politician syndrome. It is that if you change the name, you change the substance. But when you actually look at the substance here, what you see is, yes, we have just one called most economically advantageous tender, but this can be assessed either on the basis of price alone or on the basis of cost. Cost is essentially a more intelligent measure of the price, because what it means is that, for instance, you take the price of, say, buying a printer, and you take account also of, okay, now I have the printer, but I need to use ink, I need to use electricity to operate this printer. What will it cost me over the lifetime of this printer to be the owner of this model of printer rather than a different one? But still, we are looking at a variant of the price, just a more complex or more intelligent one. And then we have what we have been obliged to call the best price quality ratio. In fact, if you look at it, what this is what under the current directives is called the most economically advantageous tender. So the reality is that, yes, there is a change of name, but in substance, the reality is that you have three different award criteria which are possible. You have price, you have cost, and you have what is now the most economically advantageous tender. And of course, this is not perhaps the most clear way of doing legislation, but that was the unavoidable price to pay, that we send a political message. You should focus on other aspects than simply price, without at the same time depriving contracting authorities of the flexibility of using just price, for instance, when you're buying something where really the quality is so standardized that it doesn't make sense to look at anything else than price. And also, we've had to explain all this to quite an extent in the recital. And here I'd like to come back to the remark made earlier about the distribution of explanations or rules between the articles and the recitals. Because much of the negotiations were done under the presidency of a given commission in Parliament, where the President was of the opinion that the quality of a piece of legislation is inversely proportional to the number of words used in that piece of legislation. In other words, we were simply quite often told, well, you can't give these explanations in the article itself because then it becomes too long, it becomes too complicated. On the other hand, the explanations were necessary, and therefore the only choice was that to place them in the recitals. Even though if we'd respected fully all the principles of better legislation and so forth, they should have remained in the article. But the compromise was that, okay, we had to reach an agreement because otherwise we would not have been able to obtain the various objectives. But the price to pay was that indeed you cannot just limit yourself to look at the articles. I very much invite you, if you have a problem of public procurement, look also at the recitals, because very often the answer to the problem you're faced is actually set out more or less explicitly, but it's actually set out in the recitals. But okay, that's a little side issue. One change we also did in the context of contract award criteria was to, in fact, correct the jurisprudence. Because there is a famous or even infamous judgment called Lianakis, which is often read as prohibiting taking the experience of the economic operator into account at the stage of award. What we've done this time round is to say explicitly that the award, the organization, the qualification, and the experience of not the economic operator as such, not the company as such, but of that specific team that is going to perform the contract, that is a valid award criteria. And personally, I must say, I'm quite happy that we managed to get that through, because the other position was not very well founded in common sense, to say the least. And as was mentioned earlier, member states do have the possibility of excluding or restricting use of price or cost only. But again, as was said by the minister this morning, if you do that, of course, you deprive contracting authorities of the flexibility of having all three award criteria at your disposal. So it is a matter to be decided whether you want to keep that flexibility or whether you want really to focus on the best price quality ratio. One very exciting feature in the new directives is that we have set in explicitly the possibility of using life cycle costing. Not to say that is not possible under the current directives, because it is possible and it is also being done, but with a considerable degree of uncertainty, because this is a bit an unknown territory under the current directives. That is why we've set in explicit provisions in the new directives and as you can see, what this allows you to do is to take into account not just the costs which are borne by the contracting authority itself, and I already mentioned the example of not just taking the purchase price, but also the operating cost or the cost of getting rid of, say, the machines you bought at the end of their lifetime, but also to take into account the costs which are imputed to environmental externalities. One of the examples is, of course, that when you're buying cars, you can take into account what are the costs linked to the CO2 emissions of that particular car, and use that as an additional parameter when awarding the contract, together with, of course, also the economic aspects. What I was also mentioning before is that part of the simplification is also that of giving additional legal certainty. And an area where we've done that quite a lot is in respect of public-public. And I'll reassure you right away, I'm not going to examine that in detail because that is still quite a complex issue, but I'll just give you a few remarks on that issue to illustrate my point. First of all, what we put in very much builds on the existing jurisprudence in Tecal, in Hamburg, Coditel, and so forth. And what we cover is, on the one hand, in-house with sole control, that is where you have one contracting authority controlling one or more dependent units, or also where you have joint control, that is where a series of contracting authorities operating together can control one or more series of other bodies. And the whole issue here is, of course, to what extent can you award a contract to one of these controlled entities without applying a public procurement procedure. Besides that, we have also codified the so-called horizontal cooperation, that is where a series of, here we go, of contracting authorities go together to try to solve a given public service task. And all this is, of course, giving more certainty to contracting authority by being a clarification and a codification of jurisprudence. But actually, it is also more than that, because the directive then goes on to regulate a series of aspects which have not been dealt with so far by jurisprudence. Not least what I've called the bottoms-up approach. There's the possibility of a contract being awarded by the controlled entity to its controller. That has not yet been subject to jurisprudence, but nevertheless, we have an explicit provision to state that that is possible in the case of sole control. We have also, the current jurisprudence has as one of its conditions the fact that the controlled entity must provide the essential part of its works or services for the controlling contracting authority or authorities. But of course, a concept like the essential part, that's a bit difficult to handle, because exactly what is it? Is it 95%? Is it 70%? What is it exactly? So here we've gone further than jurisprudence by setting out explicitly that this means more than 80%. And we have also gone further by providing for private participation up to a very limited extent, but in certain cases of public procurement, which is in the current stage not allowed under the jurisprudence. But one of the major changes in the directive is what has happened to services. Because in the current directives, we have this distinction between Part A service, Part B service. So in clear, in the current directive, the system is that you only apply the directive in full to those services which are explicitly listed in Part A. Everything else, you have very limited obligations on the directive. Actually, with the new directive, this is turned completely round. In the new directive, the starting point is that all services are subject to the full set of rules unless either it is explicitly excluded from the scope or it is exhaustively, explicitly mentioned in an annex. And again here, I would draw your attention to this recital 119, because it gives you quite some explanation on exactly how to interpret the annex, but that I'm not going to explain the mechanics of it. But what happens if you are faced with a service which is under this in this annex and therefore subject to what we call the so-called light regime? Well, what happens is that these services, which are in particular in the field of social, health, and cultural services, well, they are subject to specific and simplified rules as of a much higher threshold, 750,000 euro for the public authorities. And what is also quite important is that we've come very near to making an exclusion from the treaty. The lawyers among you will know that that is simply not possible. And in fact, what we have done is to give an explanation, again in a recital, that normally, unless there are, in the specific case, indications to the contrary, normally these services below the threshold do not present a certain cross-border interest. If you translate that, well, that means that if they don't have a certain cross-border interest, well, then they are not subject to the treaty. But of course, the treaty doesn't have thresholds, so we cannot say this as a 100% rule, but what we can do is to say that normally, unless you have indications to the contrary, like, for instance, EU funding, well, that is the case. If we then have a service which is subject to the light regime, what happens? Well, there are only very few specific rules, not least the obligation to have publicity at EU level before you award the contract and after you award the contract. The remedies are applicable. There is an obligation that the national provisions to be set in place have to observe the principles, of course, of non-discrimination and national rules, and some of the horizontal provisions in Title I of the, or rather, the horizontal provisions in Title I of the directives are applicable. For instance, the provisions on the observance of applicable social legislation is also applicable to these light regime services. And again, here member states may impose use of best price quality ratio as the only award criteria. This chapter is applicable essentially to social health services, but also a group of other services. And if you're sitting and wondering, well, what is the red thread? Is there any common denominator in this strange collection of hotel services, legal services, and so forth? But the real answer is no, there is no common line behind them, other than their inclusion was necessary in order to obtain the compromise. They do present, though, one common point, namely that all of these are currently B services. So what we have not done is to transfer any current A service, that is service subject to the full regime, to the light regime. On the contrary, the new set of rules will make the full regime of the directive applicable to quite a huge chunk of services which currently are subject just to the to the limited rules for B services. Now, these are the main points I wanted to cover of some of the new features in the directives. But of course, the directives are not directly applicable. They still need to be implemented in national legislation. As we heard this morning, work is very much ongoing. And on our side, well, we are not sitting passive in that context. What we have done is very much to focus on assisting member states in obtaining a correct implementation this time round through a series of meetings with national experts on those issues which member states feel were most in need of additional explanations from our side. And also with a series of contributions. We've had already last year 12 full days of meetings on this issue, and we are planning at least further 7 days of meetings. Plus, we have an intensive exchange of assistance in bilateral meetings or by emails with member states. So we, from our side, are not sitting back passively, say, well, okay, now the directives are adopted and that's it. And just to illustrate this very quickly, I'll just give you a quick view of what has actually been covered as issues. And you can see we have so far covered quite a lot of the most crucial aspects. And we are, in fact, already next week, having the next set of 2 days meetings. So we are trying to assist member states as much as possible in their work of implementation of the directives. But of course, member states have one very important task here, which is, of course, to make a whole range of political choices, because many of the provisions in the new directives give possibilities to member states. They don't impose a given solution, but they give the possibilities. So member states will need to decide when implementing, do we want to use this possibility? Do we want to use it in full? Do we want to discard it? So that discussion and debate has to take place. Thank you very much.
And thank you very much. Tack så hemskt mycket för den presentationen. Jag tänkte på föregående talare som poängterade samma sak som du gör här nu, att det finns ett ganska stort utrymme för upphandlare och leverantörer att agera självständigt, bara man är medveten om vad direktiven faktiskt innehåller. Och du har ju gett oss en inblick i det här. Upplever du att den medvetandegraden är lika på samma nivå i alla EU-stater, eller skiljer det väldigt mycket?
Som så ofte, ja, nej. Fordi det vi først og fremmest oplever, er, at der er en vældig forskel på kendskabet til reglerne inden for forskellige typer af ordregivende myndigheder. Altså eksempelvis kendskabet til reglerne om offentlig upphandling i en lille landkommune, som måske har 3 udbudsprocedurer om året. Det er selvfølgelig ikke det samme, som det er i en stor indkøbscentral, som har hundredvis af udbudsprocedurer per år. Når det så er sagt, jamen, så er der forskel selvfølgelig på graden af kendskab og den måde, man håndterer reglerne fra den ene medlemsstat til den anden. Allerede fordi der også i en række af de nyere medlemsstater, men der er måske et mere generelt problem med administrativ kapacitet i al almindelighed. Og hvorfor skulle det så ikke også gælde for offentlig upphandling?
Finns det frågor från publiken? Vi hinner med någon kort om det skulle vara så. Sen ska vi gå vidare i programmet. Får jag be de paneldebattörer som jag hoppas finns här i lokalen, om ni inte har utrustat er med en mikrofon nere hos vår ljudtekniker ännu, så kan ni gå dit och göra det, så går det lite raskare sen när vi ska börja. Ja, vår specialfrågeställare, 3:e gången idag, varsågod. Vi ska ha en mikrofon också så att de andra hör vad du säger. Sen fick jag en kommentar från en i auditoriet här förut att när det är djupa basröster så kanske det kan behövas vässas lite grann så att alla hör bättre. Du kan också hålla mikrofonen väldigt nära din mun. Ja, den har redan kommit dit. Ja, så du får tillbaks den. Tack så hemskt mycket ändå.
Ja, hallå. Jag tänkte det är 3:e gången jag ställer en fråga, men frågan är densamma som nummer 2 som jag ställde till justitierådet Eskil Nord här. Du förklarade ju väldigt bra här, tycker jag, att när man tog fram de här nya direktiven så ville man ha så kort som möjligt. Så man flyttade en del gamla artiklar som var med i gamla direktivet till preamblerna. Den praktiska frågan nu då för implementeringen. Är det tänkt att nationella lagstiftaren även ska implementera preambler? Kan man implementera preambler? Eller hur är tanken egentligen?
Ja. Altså, tanken er jo, at vi står over for direktiver og ikke forordninger. Og det vil sige, under alle omstændigheder, så er det relativt problematisk, hvis man tager direktivets tekst som sådan. Normalt skal implementeringen på national plan, den skal tilpasses til anden national lovgivning, til national tradition for lovgivning osv. Og når man formulerer de bestemmelser, der gennemfører artiklerne, men der er det helt klart, at man ikke vil kunne foretage en korrekt gengivelse af meningen med direktivet, hvis man ikke også kigger på, hvad der er i præamblen. Så på den måde kan du godt sige, jamen, at man er nødt til også at implementere præamblen. På den anden side, man tager jo ikke og skriver præamblen af som en præambel, men selvfølgelig indholdet i præamblen skal give baggrunden, skal give forståelsen af de bestemmelser, man så indfører til at gennemføre begge dele, både artiklen og præamblen.
Nöjd? Toppen. Då är vi också nöjda, för vi måste gå vidare i programmet. Vi tackar så hemskt mycket, Claudio Romanini, för den presentationen och den inblicken i vad som ligger bakom de nya direktiven. Och en blomma, naturligtvis.